Morning. Planning Board is now in session. The agenda item for today is the approval not required for 84 Main Street. This is the fourth time that we've met on this subject. The first one was third time, correct. We had a meeting on, was it July 14th. We met again last Friday and had a meeting. That's why I'm thinking it's 4, because we had a meeting scheduled for yesterday, which we did not hold, and then we have today's meeting. When the A&R was submitted, the plan was reviewed by the town planner and then sent off to town council for his review. And so we've benefited from that, I think. And town council was here with us this morning. We also have one of our selectmen here. So I think what I'd like to do is
I think the selectman wants to be here as a general citizen, not in the role of selectman.
great. I'm just trying to be respectful to the elected officials. I think what I'd like to do is ask the town planner to give us an overview of the process as far as how we got here today. And then I'd like to get into some initial questions to clear up some things that we've had questions on since the A&R was submitted. So, Jenny, can you give us a little chronology on the process and how we got to this point today?
Sure. So the plan was submitted to the planning board on July 9th. The first meeting, as you said, was July 14th. The planning board reviewed that and wanted more information from town council, so we scheduled a meeting for last Friday, July, I believe it's 24th. I don't have a calendar in front of me. I apologize. At that meeting, there was some questions that came up that we wanted to continue this either to yesterday or today based on having some follow-up conversation with town council. During that time, Moss Development was the original applicant with the owner as Jennifer Burchill. Last week we received an email from the owner's attorney, William Pizzoni, indicating that the client's agreement or contract with Mr. Moss has been terminated, but they wish to proceed with the application presently before the planning board. On Friday, the planning board did have some questions about the application and who submitted it, and the owner, and the plans indicating that it is Robert Moss as the name on the plans. The other question we had was just some access questions, and here we are today. And we do have one of the owners here, Mr. Deli Piscoli, who's Jennifer's Burchill's. Yes. And we do have town council.
Thank you. So when we speak, we have to speak into the microphone.
The microphone is...
Council has one, and there's one right there. What I'd like to do is pick up from where we left off relative to the application, the Form A, and try to get that cleared up. It says here, name of applicant, Moss Development Incorporated, on line 1, and down on the signature of applicant, it's actually Jennifer Burchill. Could you clear that up for us? You can take it off. It just squeezes off there.
So, is it on?
Yeah.
Mr. Moss, as you know, had the property under agreement. As such, we were required to sign the plans. And Mr. Moss defaulted on the agreement last Friday, 10 days ago.
Excuse me, but I think the microphone is not on.
Oh, that's with town council. Right.
Try the switch.
There's no switch.
I'm going to switch them for now and then change
I'll give it back
batteries.
to the
Yeah.
town council. Oh, here we go.
Oh.
There we
Okay.
go.
All right. So, under the purchase and sales agreement, it is required for us to sign necessary papers and so on, including deeds and so forth, like would be required at a closing, A&R plans, whatever, prior to the actual closing. Closing was scheduled for last Friday. Mr. Moss, as you know, defaulted. He approached us to look for an extension. We denied that. I think that's been well publicized, and I've been working with the town since, and my wife and I. I am, the spokesman. I do have power of attorney. My wife is a homemaker with 3 children, and she's a very busy schedule. So I've been working with both the selectmen and the town planner and the town manager on coming up with concepts to protect the property in perpetuity. In the meantime, there's a plan in front of you that we are the owner of the land, and that's what's in front of you today. And that's why and we were the owner when this was signed. So there's been no change of ownership. And does that help answer the question?
The question, thank you, but the question wasn't relative to the owner. We'll get to that. It's the applicant. Line 1 says Moss Development, and the signature of the applicant is your wife. So are you telling us that that was if you look down at the bottom of the sheet, it says signature of applicant?
I simply think she wrote in the wrong line, and it was more of let's call it a typo. But it was her free act indeed to sign the A&R application at the time. Because we were under contract, we were obligated to.
So that was just a simple, we do it, all of us do it.
Well,
Put our signature
for what
on
it's
the
worth, my
bottom.
wife is not in real estate.
So-
This was in her name for family planning and estate planning, since a lot of families.
Let's go to the next one, which is the owner. A few minutes ago, you made it clear that you are the owner of the property and have been for a while.
That's right.
And then on the form, it says signature of owner, and it looks like a scribble. Do you know where that came from?
I do not. I think, though, that a lot of this was cleared up via an email that was sent to the planning board at some point. I think that was made reference in the opening statements by the town planner. But, I would hope that would clear up any ambiguity there. But, Jennifer Burchell is the technical owner. She's my wife. I have power of attorney.
So, right, the email that we received, it's the last sentence of the first paragraph. As advised, my client's agreement/contract with Mr. Moss has been terminated. However, they wish to proceed with the application presently before the planning board. The planning department was in contact with Mr. Moss yesterday on the phone, and he indicated that he's still in the picture. that he's still the applicant. Is that correct?
Hillary had called just to see if he wanted to withdraw, and he just indicated he was proceeding forward with the application. He didn't say he was in the picture or anything like that. He's just proceeding forward with the application.
I think it might be best just to clear it up that Mr. Moss is not in the picture. He has no contractual obligation to the property. At the time that this was submitted, he did. Currently, he does not. My attorney asked that you just simply reference my wife as both now the applicant and the owner and proceed accordingly. The plan's in front of you, meets the dimensional requirements. That's all that's changed. Mr. Moss I have no connection with Mr. Moss whatsoever. I'm not going to get into all that other than to tell you that, Mr. Moss did want an extension on the property. I denied it with the hopes that the town will form a partnership with the owner and move forward in a positive light for everybody's benefit. Just like when I bought the house in 2012, and nobody else stepped up. I did. And I stepped up again when I didn't extend the thing to Mr. Moss. And I'm in talks right now with the town and I think that's been clearly stated, and I'm sure you know that. I know that doesn't necessarily refer to the exact, dealings of the A&R, but I think it's very important that, we protect our private property rights, and that's what this is about. There's no intention to act on our end until conclusions with the town's discussions have either resolved what I hope is a positive outcome, which I have every confidence it will be, which I think everybody will be happy with. In the meantime, we want to be sure that our rights are protected, and this plan basically does that temporarily until we conclude our conversations with the town, which are in process. They were as recent as yesterday. So I would like you to understand that Mr. Pizzoni does represent us, couldn't be here today, but did send an email and did speak with Jennifer yesterday, or somebody here, and explained that Mr. Moss is not in the picture. I'm not happy about it, but it's the way it goes. I wasn't happy about that the house was going to be torn down. All right? So that's why it's not extended, plain and simple. As a matter of fact, for the benefit of the public, not that it's necessarily germane to here, to this exact application, I tried to get him to work with Jennifer, there's an email to that effect, to proceed with maintaining the house and also working through maybe building some additional houses, that type of thing. But that went nowhere, fell on deaf ears, unfortunately. But I was powerless to do anything. When I had the power to do something, I acted.
Counsel.
Yeah, Mr. Chairman, members, just to clarify, the reason why a planning board asks these questions is that this is an extremely technical statutory process, and everything has to be in proper order. So the applicant, if it's a corporation, and this is a corporation, normally it's signed by a corporate officer. There's a little confusion about that as to who signed it, applicant, owner, switching names, and that's a normal analysis by a planning board on an A&R to ensure that what is before you is clear and accurate. The other issue, Mr. Deli Priscoli has indicated that the applicant, the corporation, is out, but unfortunately in the record you have a contradiction or a discrepancy by the applicant indicating to staff of the planning board that he is not withdrawing this plan. So that leads into another analysis that the board has to make, and that is whose plan and who has the interest in this plan. And I think that that's what you have to discuss and interact with as the next step before you get into the substance of the plan.
So I think you've clearly stated the current status. You're the owner and the applicant. The form here doesn't say that. So we may need some guidance as to whether or not or how to proceed with that beyond what's been stated. And I appreciate, I have knowledge, and I believe that the board has knowledge of the meetings that you've had with other town officials relative to the moving forward. And as you clearly stated, that's separate from the A&R process. And our focus here has been and continues to be focus on the A&R and to make sure that we perform that process properly, not just for the public and the town, but for the applicant, to make sure that we get through that process in a clean manner and take the appropriate action. So we remain focused just on the A&R and hopeful and optimistic that the other piece, which has nothing to do with this really, will move in a good way.
Okay, could I just
Sure.
interject, if I may, through you, Mr. Chairman? I proceeded in good faith with the town planner and so on, and this A&R is part and parcel to what is being talked about with the overall package. That it demonstrates what the land is, and I think it's very important for the discussions going forward that you look at this, even though this is one item, that it is looked at as a package, and keep that in the back of your mind. I understand there are technical issues that Aldo eloquently explained, but I think the picture really is that where the applicant, where the owner. We are in negotiations with the town. Obviously, I think it's no secret that the negotiations are to figure out how to protect this property as it's currently configured. But things have to be determined, and the A&R is part of that.
Sure. Yep. Before I move on to the next piece of this, I'll ask if the board wants to say anything. Mrs. Bartolini. No,
I don't think I don't have anything to say right now.
Mr. Jenks?
The next piece being what? Excuse me.
I'm going to, there's the administrative part of this, which we've covered, the Form A, the discrepancies on Form A. We had to go over that to get that cleared up. And it was a little bit, well, I wouldn't say frustrating, but, we're at this tail end of this, the 21-day process, and it's not until today that we really got it cleared up. I think, we got the email last week, but then there was I already went over that. So anyways, there's this administrative piece which I think has been cleared up verbally today. The next piece we need to go over is to get into the technical part of the A&R. And
Okay.
I believe there's two pieces to that. One is relative to the easement and agreement for the septic easement, and then the other part is the stream. So
Okay.
the next thing I want to talk about is the
The meat of the A&R.
well, this is a piece of it that I want to address separately. I mean, in conjunction with it. Counsel.
Just lawyers tend to be extremely technical, especially when law overshadows everything. But just one final point, and I'm sure Mr. Deli Priscoli can address it, and that is that plan, as submitted to you, was submitted by a commercial business corporation. And he is the applicant. It is a plan that is not the plan of the owner, so you just want to make sure, on the representation of Mr. Deli Priscoli, that the rights of that plan, the ability to carry that plan forward for your consideration, have been, in effect, assigned, that he does, as the representative of the owner, Jennifer Burchill, have the assignment of that plan, and we're not going to have an issue where the corporation is going to later say that that plan was not the proprietary interest of anybody but us.
Yes, John.
Just as you know, there was some work done on the property, some grading work and some landscaping work, and this work here and other work, staking out and things of that nature. There was also contractual requirements. All of that went south when the agreement. These plans, as well as the work that was done in the yard and the surveying work, are all liquidated damages to the owner. So the owner owns anything relating to that property.
Mr. Jenks.
Mr. Chairman, I think it would be prudent if we had a motion to accept the owner's explanation of the administrative questions and discrepancies on the application.
Are you making that motion?
Don't you make all the motions?
Let's,
I'd be happy to if...
counsel.
I don't want to keep intervening if I don't have to, but procedurally that's permissible. It's usually, ultimately, it's the overview of all ministerial and administrative matters and all substantive with one vote. But if the board chooses to address that issue separately, it's within your purview. I just don't know historically what you do if you wait to address everything at the end in one motion, or whether or not you break it up from the ministerial administrative issue, which is the application, and the substantive issue, if any, which is the endorsement of that plan.
I think we have an owner who has indicated that he would like to move ahead with the town and is in conversation with other town officials. We raised some administrative questions, some procedural questions. He has explained them. I think it would be prudent to take a vote to accept his explanation of those. And I also think it would be nice to have it on the record that he does have ownership of the plans and through the liquidated damages clause.
Mrs. Bartolini.
I accept Mr. Deli Pascoli's explanation. I believe everything's valid, but I have a question. As accurate as everything you've just said is, before us, we have a piece of paper, getting to what I think town council was alluding to. We have a piece of paper that still says we have Mr. Moss as the applicant. So there's two things that I guess I question. Do we need a new filing that shows legally on a piece of paper that the applicant and owner are submitting this? Or would it be better before taking votes to discuss the A&R that is before us as to the issue of access, which is really, do we determine this to be a subdivision or do we determine this to be an A&R? And vote towards the end. So that enables us to discuss what's before us, give guidance on anything that may need further clarification, and then we can figure out whether we're going to need, whether we don't need any additional filing. We do need a new piece of paper, and then we meet and do that, or whether forget any A&R filing anyways, because we see it as a subdivision.
Obviously, that's on, I take it? All right. Obviously, the owner, as he has represented himself, has the ability to withdraw without prejudice, and it should be without prejudice, and resubmit accurately whatever he chooses. That's one option, but he's not compelled to do that, but he can. What you've got is a procedural motion that's starting to develop of whether or not you're going to consider the status of the four corners of this application as it is, and then move on to other aspects of it or not. It's all the discretion of the board. It's how you decide to administrate that. It's the four members up there by your majority are going to make that decision. I can't respectfully make that decision for you, at least not to that point.
Mr. Stein?
First of all, I want to thank you for the action you've taken, as just being as a citizen of the town. And I really appreciate, personally, your efforts to work with selectmen toward, as you put it, a positive outcome. I want to actually ask counsel. I'm just trying to, and I respect and I intend personally to, look out for your rights as the owner of the property, and I support cooperation. As you put it, it's part of the package. The A&R, I understand, has nothing to do with the long-term objectives here, but
it's part of the discussion.
It's part of the discussion. We can't get around it, at least emotionally. But technically, I do want to get something clear as far as Moss Development is the applicant, Jennifer Birchall is signing the form, and we're not sure whose signature is actually on the signature of owner, are we?
Well, that's my wife's signature where it is, but it's in the wrong line.
But below that,
I'm
do
not
we
sure.
know whose signature that is?
I never saw. I just when I brought that home one night to have her sign it, that she signed. There was no other marks on the plan.
Okay. Does anybody know whose signature that is? So, my question for
counsel is... It could be Mr.
is,
Moss's signature.
I mean, to me, this is just a straightforward, and in the context of cooperation, I just want to do the right thing as a planning board member here. And I wouldn't deny this A&R just because of the relationship to, a past potential seller or some, long-term outside issue. Do you follow what I'm saying? I just want to do the right thing technically, so that we can move forward, as you said, in a positive direction with everything being correct.
And I respect that. I respect all the opinions here today, and I think I've worked closely with Jennifer, your planner, on this, and I think she's clearly aware what the status is as far as who owns what and who's applying for what.
Okay.
I guess I should have probably come in with a corrected application today. We could clean that up today during the meeting if you'd like. I have the power of attorney. I could, if that's what it helps. That's up to you. I mean, or we can do it through the record like this, Mr. Jenks has suggested. I'm interested in closing the chapter on the A&R so we can move forward. As I am moving forward, this, it's all happening simultaneously. There's a lot of moving parts, I think it's very clear that the likelihood of this thing ever being acted on in the real world is minute. But without that, it's part of the value of the property, and it's part of the rights of the property owner. Forget about the personalities and everything else sitting, and what happened or didn't happen. The private property has rights, and I think I've certainly showed initiative, and I appreciate you acknowledging that.
Yep.
That spirit is there. I called your town planner on the weekend. The moment that agreement blew up, I made her aware that I am not moving forward, even though I was asked to, and even though it has great impact on me financially, because for whatever it's worth, there were financial maneuvers I was making on other properties, for my business and so on. So, whatever, I let all that slide and took the hits, because the bigger moral picture here is to work with the town, and that's what I did when I first came years ago. And when I had the moment to, correct what I considered was a wrong, I did. And So I'm here trying to work through this. I know it's not clean as a whistle, and for all these different reasons, but the reality is it is what it is, and I'm looking for your cooperation and commodity to move this thing forward. That's all I'm looking for, and I don't really. I'm not a lawyer, thank God. So but
You knew that was coming. At some point in the meeting.
Although I've known Aldo, in Hudson for, I don't know, probably 30 years now, 25 years anyway. So I'm pretty well known as a community guy, and I really am interested in working that through. Obviously, none of us can sit here today and say it's done, because it isn't. But it's going to get done. I'm very confident of that. Your town planner's been at the meetings. I think that's as far as I can go with it, other than to give people the comfort level that we are going to try everything to get this thing resolved prior to anything changing out there. And that's our goal. And that's why I took the steps I took. I don't know what else to say, because that's the reality of the big picture. I know that doesn't direct to your, you're looking at the very, your counsel said, the four corners of what's in front of you. And I understand that. I just want you to know and be comfortable that the reality of it is it's just a component of what we're really looking at. It's a very important component, however, and because these rights are being forgone, are going to be, put behind us, and I think it's important that they be established. That's the issue.
Counsel.
Yeah. Mr. Chairman. And yes, I knew at age 10 that I was going to be a lawyer, and I'm Jesuit educated, so that also is a cross that I bear. But at any rate, having said that, clearly Mr. Deli Priscoli, as representative of the owner, is attempting to operate in good faith before the board. There's no question in my mind sitting here. One of the offers, and I think one of the potential solutions technically, so that we don't have any potential subsequent administrative or ministerial legal issues, is the prospect of resubmittal rather quickly and further hearing rather quickly on a cleaned-up version of the application. That would allow for withdrawal without prejudice, a submittal as soon as today in proper form, and if it's going to be with that plan, then it can be with that plan, and subsequently having a further hearing, or I should say meeting, it's not a public hearing, as soon as possible. And that way you end the issue of the administrative confusion here and the discrepancies of what the applicant's telling you versus what the owner, and you can move into the substance of the plan, which is the intent of the statute anyway. That's probably the best way to do it, and I think Mr. Deli Priscoli was suggesting, cleaning it up, and unfortunately we're burdened by how do you do that right. You just can't do it today, but you can do it very quickly by a resubmittal and a hearing within 7 days at the most. I mean, you're supposed to, this is confusing, but all of the substantive issues are well known now, and Mr. Deli Priscoli is clearly competent with dealing with it, so there would be no delay at a subsequent meeting in getting into the substance of the plan.
Mr. Stein.
I am curious to hear Mr. Deli Priscoli's response to what counsel just said. To me, that seems like the best way for us to proceed, and the cleanest, and we, in a cooperative way, move in the right direction for everybody.
Well, I think I need to ask the board, is there any zoning change impending of anything? Is there anything going to be advertised in the next 7 days?
The answer is no.
Okay.
There is no zoning impediment.
Okay. So I think, there's another option, but there may not be under 40A with this, I'm not certain, which is I can choose to extend the time frame. I know you're not obligated to ask for, you can't force us to ask for more than 21 days, but I can offer more than that, or can I not?
Well, I'll answer that through the board, but normally you could, but the weak link here is the application.
Okay.
So you're extending a defective application, which creates, we're back to the beginning, which creates the problem. Again, the cleanest way is resubmit, withdraw without prejudice, resubmit if you wish today, and remark this promptly for a substantive consideration. That way all of the administrative issues are gone.
I would consider that once. I would like to go through whether it's we're here. I would like to talk about the plan, because if the plan is ultimately, okay, so say you had a clean application in front of you. Let's do a hypothetical, okay? If this plan's going to be denied because you're saying that there's a drainage ditch in front of the house and I don't have practical access, you might as well tell me today, because that will affect where I go with the selectmen. So I need to know if that's ultimately, when there's no need, let's not dance around the 900-pound gorilla. Let's just talk about it, because we can do that under a workshop, a format. We're here, the public's here. Everybody's taking time out of their beautiful summer day to be here. I'm trying to get this thing resolved in a positive light for everybody's concerned. There's a great chance here to have everything come out where everybody, other than Mr. Moss, are probably going to be quite happy. But that's behind us, all right? And so I can't fix that. His approach was not my approach. My approach was in an email to Jennifer. I'd like to, I don't know, Mr. Counselor, that if we can do that, I certainly don't have a problem in the spirit of cooperation and I want to be cooperative. I'll work with your town planner to refile the thing today, if that's what it is. But if we're going to be right back here 7 days from now, and I'm going to be denied, you might as well just tell me that. In all fairness.
And the answer to that question, the answer to that question is that the owner's representative is not compelled to withdraw without prejudice. That is his discretion, and you have to consider those issues in conjunction with the substantive. So if you choose, you can move into the substantive issues.
Mrs. Bartolini, you had your hand up.
Congratulations, you've all caught up with me. That's exactly where I was. We can and I do think that a resubmission is probably the cleanest way of doing this. But if we did that, I didn't want to curtail our ability to look at what's before us today, although technically it's not before us by
Well, it is.
the land. Well, it is, and it.
Because the way to work this is, and I think council would agree, is to talk about it as if the plan hasn't been withdrawn, and then withdraw it
Right.
At the end before a vote is taken on it.
I wanted to I'd like to discuss this. Give you our questions. Give you a chance to respond to them, and then give you advice as to which piece of paper you may be filing. A&R or subdivision, either way. And I think we can't get there unless we talk about some things as opposed to Mr. Moss.
And I agree. I think we should use this time productively and try to resolve issues that we can. And then I think I'm going to take councilors' advice and your encouragement to clean the plans up. But I'd like to see where we go with this. And, I'm hoping that we can have a positive resolution to this and move it forward. That's the goal for me, anyway.
A guy I used to work with when you got to this point in the meeting, he would say that we're in violent agreement. So what I'd like to do...
I heard that expression, but that's good.
What I'd like to do then, if there's no objection, is to go to this document which refers to the septic easement, because I think there are things in here that we would ask you about, and
Let me give him a copy so he
have you
has
seen
it.
this, John?
Yes, we sent it to you.
Yes, okay. Do you want a copy?
So what this is for the public, Jen, can you point, Phil?
Do you want me to put it up on the board? Would that be helpful on the
No, we can hold it up. But just point to the,
I think up on the board makes sense because that way the audience sees it.
all right. There's a, So there's a document here, it says clarification of deed of easement and agreement recorded in, and there's a book and a page. And it's dated January of 2012. And it has to do with that easement that we talked about, well, we've been talking about since we got the plan. And there's some highlighted areas, I'll just refer to those, where the parties agree and wish to clarify and provide further insight as to extent and the intent of the easement, and as such, they state as follows. The rights of easement granted in the easement agreement were noted as, and then, quote, over, above, and below the surface, end quote, at the area located on 84 Main Street. And then the next item says, it was intended that the grantee have rights below the surface for its soil absorption system and to also have rights over and above the surface of the proposed easement area only during construction, reconstruction, or for maintenance of the soil absorption system installed therein. The next item says all other surface rights after construction of the septic system shall remain with the grantor, and the proposed easement area is to be maintained by grantor as a grass and landscaped area, to be maintained so as not to have an adverse impact on the integrity or operation of the soil absorption system. And then another item below says, however, no structures or plantings may be placed or erected thereon, or the landscaping altered within the proposed easement area unless grantor, and then there's talks about payment and other things.
Amendment 2, if you go back, there's an amendment.
And then it says another item, any proposed structures, plantings, or alterations of the topography of the surface area over and above the proposed easement area shall not interfere or be detrimental to the soil absorption system installed therein. And what are you referring to, Jenny?
There's just for the record. There's just a clarification of deed. So I don't.
Yeah, I read that.
Oh,
That's why you
the
were
one
setting up.
reading.
Yeah.
Okay.
So, I was going to ask John to explain how they can get across that to a proposed home. Before I do that, does the board want to do it a different way?
Well, the rights after the system was constructed, the system, for clarification, there's a home that's right on the smaller, like, ranch house.
That's
right
the
on-
one on Parkerville
Right,
Road.
that was put there. That was owned by a member of the Garfield family at the time, and the Garfields, of course, had an interest in the current property we're talking about, and they gave them they needed a setback for a septic system. The intent of this, where all the rights go back to the grantor, which is the big house owner, whoever that may be, is that that's not going to interfere. You can't go digging foundations or doing structural alterations. As far as going over the top of it, a simple engineering letter saying building a gravel driveway over that's done every day does not affect the infiltration one way or the other of a system. So I don't see that as any impediment to building a gravel driveway over that area, especially when it was clear of this that all the rights after construction go back to us. So that's how I read it, and that's how my attorney reads it.
Yeah, there was a question relative to the pipes. If the system was constructed with Schedule 40 or Schedule 80 pipes, Schedule 80 pipes would be a stronger pipe that would take a heavier load.
Yeah, well, when you have a system buried like that to get an H20 loading, as you may or may not know, I'm in the site work business, so I'm very confident and with that. And plus, you can use a structural fabric underneath the driveway, but above the system that would disperse the load. So there's many options there that don't affect the drainage, really wouldn't affect anything on that. And it was never the intent of this to have any effect on the other than to give them an area to discharge their sewage in an area that perks, since most of the lot is all sand and gravel. The purpose of that was to give them a situation, because their lot was too small to accommodate a system under the current Title V regs. So as an accommodation, we went along with that. But it was never intended that that was some kind of gate to do anything with the other property other than the footprint of that system subsurfacely is not going to be disturbed, which is not being proposed here. And I think that's clear as a bell here.
Question was asked, an answer was given. Any comments or questions from the board? Mr. Jenks?
I read a lot of cases this weekend dealing with this theory of vital access, which, as I understand it, is not a requirement of the statute. It's all in case law. And there is a history, albeit fairly brief, of planning boards denying A&Rs based on some blockage of the right for vital access being emergency vehicles, fire engines, police cars, ambulances. And it appears that only in the most severe case of blockage and blockage that could not be corrected, the applicant has won those cases, and the planning board has had to sign the A&R. I think, first, I don't think this blocks it at all. If a gravel driveway is used, and if pipes are broken, it's pretty clear the owner of the Garfield property would have to pay to repair the system and make it workable. So I can't imagine that a court would uphold our denial of the A&R based on that easement.
For what it's worth, if I may respond, Mr. Chairman, the last thing I'm interested in is legal decisions, future legal decisions. I want to once again reiterate a partnership here, that I'm not looking to have the thing tested. I just want to work together on it.
All set, Mr. Jenks? Yes. Anyone else? Thank you. Next item that I want to address, and it's having to do with the same requirement, and that would be the reasonable access to the home, to the structure, to the dwelling across the stream. Jesse, could you go up and point to the frontage? It's lot number 1. So can you run your finger around the whole lot line? No.
Oh, sorry.
And then within that lot is that septic easement that we just talked about. And now we're going to talk about the stone-lined stream, which starts over there on Main Street and flows down all the way through Lot 1. And the question is, is there reasonable access to the dwelling across that stream? So I guess that's the question. We'll be very interested in your answer.
Okay. First of all, signing an A&R plan, regardless what it is, as long as it conforms in the sense of shape, frontage, and so forth, does not guarantee a building permit to the holder of the A&R. You realize that, right? Because you're not there's no building permit being granted for any lot. You may have to go to other boards, such as Board of Health, Conservation Commission, and things of that nature. So signing an A&R plan doesn't make anything. And having done this for, when I was a house builder, 2 lifetimes ago, doesn't guarantee anything other than saying that the lot has the area, the frontage, and the shape that conforms to the zoning. So it's very common in an A&R plan that somebody has to do further permitting to be able to obtain a building permit. I don't think that's ever going to be attempted here in the reality, but that is commonly done. And on that stream basin, you may be interested to know that when I was approached by DPW to expand maybe some site retainage on our property, through some reconstruction project. I'm not sure all the ins and outs, and I don't want to get into that whole thing because I don't know anything other than I was asked if I would entertain having some stormwater retention on the property, and I graciously said yes. I would work with the town and do what's best for the community at large. So that shows you, here's an owner saying that was when I first bought the property. The stream is stone lined. It's not naturally occurring. It's a man-made structure. It'd be no different than, the only thing missing there is, the fourth side of the pipe. In other words, a pipe is, or a box culvert is essentially what it is without the top part of the culvert. It's not a naturally occurring thing. It was man-made, and I think it would be very difficult to say you can't put an H20 precast plank over that when it has no effect and there's no impact on the wetlands or anything else. I think that's a lot different than what you may be thinking of, where you have a meandering stream through, existing bank and wetlands and everything else. That's a whole where there's fill involved and everything else. There'd be no disturbance whatsoever to put a plank crossing there, because you're simply putting the top of the culvert in. Had they built that years ago with pipe, we wouldn't even have this discussion, because it would have been filled over. So really, I think because of what's actually in the field, it's a much different discussion than it would be if it was some, naturally occurring situation. But the reality is, I don't see anything crossing that stream. What I do see is I do see the invasive species asking for that to be cleaned out and have a nice landscaped area there and leave the thing alone long term. That's what I'd like to see, to be candid with you. So the view from Parkerville Road is sweeping in and across the whole property from a visual perspective. But I think having a man-made structure in the ground that flows drainage water from Main Street and other areas as a catchment area, 3 sides of a box culvert are there. So I think that's be a tough one for denial.
Counsel?
Well, I'm just gonna remind the board some of what Mr. Deli Priscoli is accurate. In the event that you endorse this plan, it has no status under zoning, it has no status under Board of Health regulations, and it has no status under wetland protection. Those are other independent legal issues which have to be addressed, if any, by the respective boards. Just to remind you, because some of it's already been said, the endorsement of this plan, if you choose to endorse it, simply indicates that what you're looking at is not a subdivision, it's not subject to your rules and regulations, and that it does one other thing, and it is that no zoning issue can be addressed here, but for the fact under planning that you are satisfied that there is adequate access to service, adequate access over the linear frontage to service each structure, if in fact structures are going to be built, by the largest public safety vehicle the town has based upon that configuration. So you're confined to that determination, and you either say, we're satisfied it's not a subdivision, we endorse it, approval not required under subdivision control, or we are not satisfied that there is adequate access. We want you, subject to our rules and regs, to create an actual subdivision road according to the regs, the gradient requirements, and offer the applicant the opportunity to submit the plan. This is totally a discretionary function of the planning board based upon what Mr. Deli Priscoli is saying and what you believe based upon what you see on that plan.
Thank you. I have, I think I have two questions more in the area of definition. It's obviously not a, those stones were put there by man. That channel was constructed. I think my first question, and this would go to you, Joe, would you consider, would that stone-lined stream be considered historic? His answer was it would. And then the other part of it would be, I asked the chair of the Historic Commission, Joe Hubley, that question, and his answer was it would. The other part is the water, the liquid. It's obviously, I presume it's governed by and regulated by the DEP regs. It's stormwater runoff. And we've had, I mean, I can't count the number of A&Rs that we've had before the board over the years, but I can't recall a situation where we've had a stone-lined channel that if it was, as you said, a meandering stream, naturally occurring, or a wetland, to me that would be a lot clearer relative to crossing it. In this case, it's a man-made structure, even though it does contain regulated stormwater. I'm not sure if there's a question in there, but your plan to address that is to span it without altering it. I have to think about that. Anyone else? Mr. Jenks.
I noticed that the land surveyor that drew that plan did not locate that culvert, nor put a dimension on it. How wide is it? Excuse me.
Well, you can just about step across it.
Okay.
I don't want to say I did not measure it today or in recent memory, but it's quite narrow and defined.
So
Maybe a yard, a little over that.
Structurally, you could put a bridge across it for a road.
Well, what you would do there,
cap it.
what you would do is, since it's so narrow and defined, what you would do is get a structural plank, a precast plank. You'd literally just lay it on a gravel bedding on either side. So there's bearing. You would have the integrity of the trench wouldn't even be in discussion because you're not going to be touching it. You're going to be basically putting I mean, we're talking hypothetically. I think it's important that we all understand that. We're looking at that end of it. Hypothetical and reality are different in this case. But hypothetically and construction-wise, you could put a plank that is structured for H20, and for the public's benefit, H20 means fire trucks, any typical truck that can run on a 99,000-pound weight limit could cross that. And that could be done literally with no work in the stream area, just dropped on there, and there it is.
So There would be a question of getting permission to do that, and that's probably a, I don't know, Conservation Commission. The plan does talk about a wetlands boundary, and if in fact it is, I assume Conservation is going to have to approve whatever you want to do there anyway. I don't think that issue is even appropriately before this board.
In the event it was ever built, Mr. Jenks, I think that I'm just wanting to make sure you knew how it would be built. So if you went to the conservation, let's say, and you explained to them that, there's no impact, you're not filling 1 square foot of anything, you're simply placing a plank and basically putting what today, let's put it this way, a better way to look at this is, I agree with the gentleman in back, historically it's been there, it's very attractive, it's stone lined and so on. But today they don't do that. They put precast square box culvert, or in this case, more than likely would have been concrete pipe, what they call RCP, reinforced concrete pipe, which you've seen on many plans with your subdivisions and so on. And it would have been filled over, and that would have been it. And this discussion wouldn't even happen. It's just that the nature of it was, and I think the intent at the time it was built was probably it wasn't going to be crossed.
I think you're right relative to jurisdiction and expertise, although our experience has been that, if you have an open channel and you cover it, the channel is fully daylighted, and covering it does have an impact, or could have an impact on the water quality or the habitat. Freddie, you got to grab the mic.
We only have one. It's up here in John's hands.
Oh, let's go.
Hi. It's on. Freddie Gillespie, 78 Southfield Road. I just, and I understand this is a Conservation Commission issue for wetland protection and riverfront area, but you're talking about this culvert, and just wanted to point out that on GIS, it's listed as a perennial stream. Back in the day, probably before the Wetlands Protection and Riverfront legislation was enacted, they may have stone-lined natural streams. So I think referring this only as stormwater and putting it in a culvert is somewhat misleading. And as recently as the Main Street reconstruction meeting with the state, they acknowledged this was a perennial stream. So it is not simply an open culvert that hasn't had the top section of the box put on. It would probably, in my to my understanding, come under the Riverfront Act. It's perennial, 100-foot no-touch zone usually, and 200-foot resource area. Whether that's different because of the stone lining, I'm not sure, but it is not simply stormwater. It's not a pipe that hasn't been installed. It is listed as a perennial stream, and the state has acknowledged that. So I think there's some, beyond the map, I think there's some authority to my making that comment.
Thank you. Be right back. Normally we wouldn't be going into these kind of far-reaching discussions, but I think that you set the table, John, for having an open discussion and trying to air this out as best we can. And I think the board is very willing to do that. And so what we'll do is break for lunch. No. Was there anything else from the board that we haven't brought up yet relative to the plan or the procedure? Jesse?
I'm not sure if that's okay with the chairman. Could we go back to the easement for a second? Just for my own, wrap my head around this. Because you mentioned the 99,000 pound limit with the plank that you would lay across the water issue there. And I mean, are you comfortable with that as far as the easement as well? That could handle, the gravel and the heavy equipment?
Yes, because the way that's built, you could, my approach would be have a geotech, which is a geological engineer, look at that and have a way of bridging the weight distribution so there'd be no bearing on the subsurface situation there. That's an engineering matter. It's very easy to take care of. It's done all the time. There'd be no impact. The reality is we're looking at an A&R plan. The likelihood of that stream being capped and looking at the nuance here really has to be discussed, but it really isn't productive to get to where we need to be, in the end. In the end, we all want to see the property protected. That's my goal. I think it's this board's goal. I think it's the people sitting behind me's goal. I think and the way to get there is to realize that you're not, as Mr. Aldo said, that you're not granting a building permit or the right to put the plank there or anything else at this point.
Well, I think it's important that we do separate. Again, I stated earlier, this board's focus is on the A&R.
And I respect that.
And we really can't look at the positive or negative impacts. We just have to look at the merits and the rules relative to the A&R and apply those. And that's our job. That's what we have to do.
And I've tried to address your questions to the best of my ability and to give you the technical reasons why this A&R should be endorsed.
We appreciate that. Yes, Jesse.
So you'll just stop me if I'm going too far with this. But is now an appropriate time maybe to ask, what is your vision for the property? I mean, it would be great if you could get up there and tell us. And again, it's more along the lines of the open discussion.
I'd like to, again, our focus is on the A&R.
Right.
The vision for the property goes beyond that. I want to really stay focused on the merits of the A&R. And again, the planning board looks at approvals not required for situations, all around with easements, grading issues, wetlands, culverts, everything. And again, I stated that I can't recall an A&R in Southborough where we've had a situation where the physical access to the dwelling is compromised by a stone-lined structure like this. And we've also had situations with these easements, both of which you've addressed. I really feel that this is, I'm leaning toward the physical, initially I was feeling that the physical access here was no different than if it was a wetland, in which case I would feel compelled to say that you do not have adequate physical access, and therefore the lot doesn't meet the requirements of under an A&R. But because of the uniqueness of this impediment and our discussion relative to the physical way of achieving the physical access and the jurisdiction, that I'm tending to feel that that the physical access is not impeded by that stream or the septic easement. Mrs. Bartolini.
I too, based upon the discussions we've had this morning, feel that we have real access, not illusory access, which is for those in the audience, that actual illusory is a term of law, meaning can you get there? And I do think the stone lining of the stream makes a difference, but not enough, frankly. I think that's still a Concom issue. I'd like to expedite this further, Mr. Chairman and Town Planner, by suggesting that with all the conversations we've just had, if we feel that feel that this is real access and therefore an approvable A&R, we take a recess, allow the developer to go in, become the official applicant, reconvene. We can't do that?
It's a new application, so you'd have to post it, and you need 48 hours to post. I wish it could be that easy, but I don't think it would be. And I don't know if Aldo has an opinion on that, but I think that you'd have to post that.
I'm an expediter.
I got to try to. Let me think of. Well, let me ask you. What has the policy practice of this board? Have you ever accepted? Comes down to this. Has the board ever accepted an amended application pending before the board that needed a technical clarification?
Yes, but not to this extent.
A signature? Maybe on the wrong line.
Well, the technical.
We've had plans that, for example, had the north arrow missing, and they were sent back. We've had them with the Form A not properly filled out, and we've sent them back. In this case, I believe, from my experience on the board, that this is a higher level of discrepancy. So I think we're back to where we were half hour ago, which is that John asked to go through the plan technically, which we've done. We're going down the line here, getting opinions from the board relative to the physical access or any other issues. And then once we finish that, I would expect that the plan would be withdrawn, and then a new Form A relative to this plan or something similar to it would then be filed, and then it would follow the normal process as the town planner mentioned.
And of course, that's perfectly acceptable as an alternative, but you now have pretty much aired out the substance of the plan, so that means that it becomes, forgive my Latin, pro forma filing, and that would be the consideration of the new application with the existing plan forthwith, is the way the law would look at it, which means as soon as you can, early next week or whenever. This would be without delay.
Let's, if Mrs. Bartolini was finished with her comments relative to the A&R, I'll keep going down the line. Mr. Jenks.
The statute under which the A&Rs operate is pretty clear that the primary thing that this board considers is the frontage on certain kinds of roads, and there's no debate about these roads being acceptable roads. I see adequate frontage for all of the 4 lots. There could be a question about access for vital access for emergency vehicles. I think what the case law looks at in those situations is that something that a landowner could deal with? And pretty clearly here, I think it's something the landowner can deal with. I see no ability for the planning board to deny the A&R. I would like to point out that I believe the rights that the owner talks about preserving is probably one right, because if this is an acceptable A&R now, it will be an acceptable A&R a month from now. But the right, I assume, is that the recording of an approved A&R plan puts a 3-year freeze on zoning changes affecting the use of the property. In other words, if the town came up with some scheme to zone the property commercial, and how likely is that? Having the A&R on record would mean that would not affect this property at all. So I think that's probably the right that the landowner is trying to preserve. I'll go back to my suggestion that we could handle the administrative things by a separate vote, accepting the owner's explanation of things and allowing him to correct them. It just seems like the easiest way to do it. That's my comment.
Well, Aldo.
All I'm going to, whatever you do in this particular case could be the pathway to how you're going to have to do other things in a similar situation. So be cautious about that. Attempting to bend over to deal with this, adequately, you could own that as a procedure in the future. It's just a caution. You have to consider that. Obviously, you make the final decision.
Mrs. Bartolini.
Just in reference to that, at our last meeting, I expressed a concern about doing something that would heighten the probability of going to court. Even when we're doing it because we think it's in the best interest overall, for long-term interest of that property for the town, even if we weren't thinking about what's in the best for a landowner. And since we know that we seem to be moving towards agreement from a town's perspective and the landowner's perspective, brought to my attention this morning by the current applicant, there's disagreement, and I don't want our actions to provide opportunity to raise delaying issues in court over who really was the applicant. So I'd rather do the paperwork so that someone can't come back and say, well, why did you believe what he said versus what I said? I came to a meeting too, and I spoke to you on the phone. I mean, I'm trying, again, I call myself the expediter. I would like to do this in such a way that we've protected the community and the abutters, and if that requires protecting the applicant, then I'm all in favor of protecting the applicant, and I think that's what we achieve by doing the paperwork.
Mr. Stein.
So I appreciate you addressing the questions regarding the access. In the context that this is not the Historical Commission, this is not the Conservation Commission, I'm in agreement with Mr. Jenks and our chairman and Ms. Bartolini that, in principle, there's no issues with the A&R plan. The issue is with Form A. And on that basis, in my opinion, if this was withdrawn and then resubmitted with a corrected Form A, I would be comfortable.
Mrs. Bartolini?
Mr. Stein's comment just made me think of something. As an act of good faith on the part of the community, by putting you through the extra paperwork, I'd like to suggest that when allowing you to withdraw and then refile, that we waive the filing fee for the second application. That's out there.
Counsel?
That is within your discretion to do, and if that is going to be the cure for the administrative issue, then, and I'm sure that Mr. Deli Priscoli's counsel will do this, my comfort level on behalf of the town and the planning board is to get some form of a letter, a real letter signed by Attorney Pizzoni that indicates that that plan has, the rights of that plan have been assigned to Jennifer Burchill and her power of attorney in the record. So if we need to, we can utilize that as a defense based upon representations by Mr. Moss that he wants to go forward on this himself. If we can do that, again, just recapping, a corrected application, no fee, submitted immediately, properly posted, acted upon in substance forthwith, and with that letter, I think that you're following the guide of case law and the statute.
I want to go to Mr. Deli Priscoli. Do you agree with that?
I mean, if we're going to file a new application, do you want me to change the title block on the plan? I'll do it. Then that ends the letter.
As a past member of the State Board of Registration of Professional Engineers and Land Surveyors, that one scares me.
Okay. I just didn't know if what we're talking about as far as, but I'll go with what Mr. Cipriano.
You could get Mr. Moss and the land surveyor that stamped the drawing to change it, but you don't want anyone else to.
So you're agreeing with
the plans, all the consideration, all the work that was done on the property is all liquidated damages when Mr. Moss's agreement ceased to exist. So I don't know what else we need to do, but I can give Mr. Pizzoni will write you a letter to that effect if that's helpful.
I'll be glad to talk to Attorney Pizzoni.
Yeah, I'll let that. Maybe that's the best bet.
I'll coordinate with him to make sure that we have a comfort letter for the town and for the planning board in that regard. So that'll be solved.
So is the next step to have John inform the board now that he's withdrawing the plan?
Without prejudice, for a immediate resubmittal properly formulated.
And do you agree that he has the authority to withdraw the plan?
We're going to take Mr. Deli Priscoli on his representations to this board today. I've never seen a comment that he's made publicly over the years to be inaccurate.
So he has the authority to withdraw this plan without prejudice.
He's saying, yeah, I believe he's saying that he does because there is no further agreement for the acquisition of this property by the applicant. So all applicant rights end, and this falls back into the owner, which is a right under the rules and regulations. So yes.
I would like to add, Mr. Chairman, that nobody here other than Jennifer, but Jennifer was there. I did share the letter that was given to Mr. Moss about the default. Do you recall that? That was at the first meeting with the town manager.
Yes.
So I did produce that. So it was crystal clear where it stood. We can certainly share that with your town council.
But going back again to the pure focus of this board relative to an A&R, we have a plan, we have an agreement now. So is the next step for John to say the magic words, I request withdrawal, or I withdraw?
Basically, he's saying that with the authority he has for the owner of record, that he is withdrawing the application to be without prejudice to be resubmitted forthwith, or something to that effect.
And before I state that, which I have every intention of doing, I would like to hear what the board, I basically see the straw poll basically on your comments. I don't think we need to belabor that, but I would like to know what the date of that next meeting potentially could be for my own planning.
Hold on, let me, the steps, if we get the new Form A and a new plan, when would we get that?
A new plan, I was going to submit the existing plan. I'm not changing the
Is the
plan.
existing plan adequate with a new Form A, Counsel?
With correspondence from Attorney Pizzoni, it would be for me.
So we get the new Form A, when would we get that?
Well, based on the homework now that I have to do, I would suggest that that will most likely be tomorrow.
So that shows up in the planning department. Take us from there, Jenny.
If it showed up tomorrow, Wednesday, at 9 a.m., you could technically meet Friday
At 9 a.m.
at 9 a.m. We need 48-hour notice to post. So it
So
depends
we're
on if
looking-
this board can meet. I'm on vacation next week, so not that that matters, because Hillary can sit in my place if you choose to meet next week. But if he could get it in tomorrow and the board could meet again on Friday, and then it. No.
I mean,
I'm just saying as earliest.
Well, right, I mean, if it doesn't show up until 3 o'clock on tomorrow or
Right.
Wednesday.
And we're closed on Friday afternoon, so.
While the town hall is closed, the planning board is always open.
Right.
We would just want to make sure we had an appropriate place to hold a public meeting. So let's find out, are you thinking that we could do that?
I'd like to get it resolved, Mr. Chairman, just so I can cross that off the box and move it forward. I think I'm flexible on Friday. I can meet late in the day, whatever works. I'm going to be up in the area in the afternoon anyway on other business. But it's really an impediment on you guys. So I'll work around what you suggest.
Let's check on availability.
Does a new application start the 21-day statutory period again?
It absolutely would. However, given the road course you followed under the first application, the board is advised to act forthwith on that because you've basically aired the issues as it relates to an A&R plan.
Good.
So unless something new comes up, this is a pro forma consideration, which is what these things normally are, except for the complexity of this plan. So yes, it does open up another 21 days, but I would say you would be acting forthwith.
Let's check on availability. Let's just talk about the whole day Friday. Is anybody around Friday?
I'm around, I just know I have a conflict on Friday, but can't even think of what it is. But I figured with you being out of town, I wouldn't have to know. I probably can do the morning if we had to do Friday. If we post on the earliest, it's Friday. So, yeah, I'll figure out a way of making myself available anytime on Friday.
Is it easier Monday?
Monday?
My preference would be Friday at 9 a.m.
I'll do Friday at 9 a.m.
Monday? I actually think I have something on Friday.
That's August 4th, correct? Yes. I'm available.
If it's Monday, either early or late.
Bill?
Late Monday.
Late being 5 o'clock?
Yeah, actually, probably afternoon for me, but
Could we make it?
or evening.
Is there a potential to make it for 5 o'clock?
5 p.m. on Monday.
Yes.
Yes.
Okay.
That'd be easier. I have commitment. that I unfortunately can't get out of.
Well, 3 out of the 4 of us are good for 5 o'clock on Monday. I think I am, but I don't have too much going, but for some reason I think I might. Yes, ma'am. Did you want to speak, Claire? Yeah, come on up.
Thank you. Claire Reynolds, 104 Main Street. I just have a comment and a question. One of the things that Aldo said was with the A&R, remember that you can be setting a precedent, or if I'm not saying this quite right. Essentially, what it deals with is you have an A&R that is not filled out correctly. So you don't want to, by the planning board not denying it, are you setting a precedent that this A&R has been there since July 9th, and now we're taking a notice that their signatures are on the wrong line? Granted, it's a small technicality, but I don't know if that was the precedent that you were actually speaking on.
No, actually, the precedent I was speaking on is doing anything but this formal process that they're following, which is withdrawal without prejudice, clean up the format so that it's accurate, and then resubmit it to the planning board with the plan for their final consideration of endorsement.
Okay, so then the question then that I have is, and I'm sure Mr. Priscoli has looked into that, the non-prejudicial, excuse my legal, without prejudice. Oh, okay, all right. That doesn't open him up to any liability.
Well, respectfully, Mr. Delby Priscoli, I can't advise on that.
Okay.
I only
all right.
represent
so I'm
the
sure
planning board.
he knows about that. Okay, and that's why I'm kind of confused as to why the planning board wouldn't just deny it, because everything that we've talked about for the last hour and a half has been that it's going to be resubmitted, so that the planning board would just deny it on inaccuracy, unless you are afraid of some type of liability.
A denial is a negative thing, and we try to work with the proponents as much as we can. So if we can avoid a denial, we do. And what we're doing, the steps we're taking now, are most consistent with this type of discrepancy relative to A&Rs. There's been many of these that it's either withdrawn
Or get bounced back
it's not,
because they
and
didn't
then
have
it
North
comes
Arrow.
back, and then it comes back cleaned up. That's really the way it's
Okay.
been going, rather than, a denial. Anyone else?
Should I make my request? Okay. I request to withdraw the plan without prejudice as the owner and now the applicant. And I will be resubmitting the plans tomorrow. Is that adequate? And I will also have my attorney speak with your town council to make sure that the application is complete as requested.
Council, do we vote to we either approve or acknowledge?
I presume you normally would vote to approve or accept the applicant's request for withdrawal without prejudice.
The verb would be accept his request?
Again, I don't know what you normally do, but the nomenclature could be to accept or to approve his withdrawal without prejudice.
Mrs. Bartolini.
Mr. Chairman, I make a motion that the planning board accept the request by Mr. Deli Pascoli to withdraw the A&R plan without prejudice, with the intention of immediately refiling the Form A to clarify that he is currently the applicant and the owner. His wife is the applicant and owner of record, to be accompanied by a letter from his attorney concerning liquidated assigned rights.
Motion's been made?
Second.
And Seconded. Any discussion? Hearing none, all in favor? Aye. 4-0. Thank you.
Thank you very much for your time today.
You don't, it's taped on. Anyone else? Otherwise, Mr. Jenks. Mrs. Bartolini.
I make a motion that we adjourn the meeting.
Motion's been made and seconded. Any discussion? Hearing none, all in favor? Aye.
Aye.